If you're looking for a comprehensive guide to XRP, then you should definitely subscribe, enable notifications, and become a member of our community. Someone associated with the XRP community and the SEC was unsuccessful during today's court hearings. Among the many former SEC chairmen, Billy Boy Henman and Jay Clayton piqued the curiosity of an attorney seeking explanations on various aspects of the law, notably those pertaining to ethics. Neither of these people has a spotless record of functioning as a reasonable chairman. The attorney finds great joy in making videos on various crypto-related topics and posting them on YouTube. Clayton and Henman, two exec officers, are named as defendants in a class action lawsuit because to the improper roles they operated in Ripple. Because of the wrong roles they performed, this lawsuit has been initiated. A large number of calls from potential Ripple investors prompted concerned XRP supporters to decide to take legal action. A representative from the United States, known as Fred Rispel, has launched a class action lawsuit against the two individuals involved. The lawsuit alleges that the two executives, Clayton and Henman, conspired to defraud hundreds of thousands of global XRP investors on behalf of their current and former companies with ties to Ethereum. This comes after the Ripple community had repeatedly asked the SEC to investigate the conduct of Clayton, the former chairman, and Henman, the former finance director. Since neither agency had demonstrated any interest in the matter, the complaint was eventually rejected. Reason being zero interest from the agencies about the matter at hand. After reviewing the evidence, Rispel has come to the conclusion that Clayton and Henman have engaged in certain dubious behaviors. Their actions have led to a class action lawsuit being launched against them. The attorney's decision to sue shows that they are angry and dissatisfied with the SEC and that they are going after those responsible for wrongdoing within the company, which is something that should be appreciated. For the simple reason that it exposes their targeting of criminals, we must not overlook this truth. The XRP community consists of almost everyone who would generally agree with this statement. The fact that this is happening fills me with joy. In addition, on May 8th, the media focused on the Ethereum debate between Haile Illegal and SEC. This case is among the more egregious examples of a law firm taking on the Securities and Exchange Commission in its ongoing fight. There is a common misconception that the Securities and Exchange Commission is not concerned about the financial security of the XRP community. However, this commitment disproves that. As admirable as it is that the lawyer is hell-bent on suing the SEC, it's downright remarkable that his or her stance runs counter to the agency's overall impression. With respect to the LLAWPC cryptocurrency companies, court appeal. July 18th has been designated as the date by the United States 17th Circuit Court of Appeals. The deadline for submitting oral arguments in reply to the appeal is 2024. The firm's lawsuit against the U.S. Securities and Exchange Commission was dismissed before it could be considered. The lawsuit sought clarification on how the company's native currency, Ethereum, was classified. The case was filed with the intention of providing clarity regarding the classification of Ethereum. The corporation and the decision to dismiss the lawsuit against them have differed. At the hearing, the judge will consider the SEC's stance and rule on whether the agency's enforcement policy complies with the Securities Act of 1933. Halal PC originally sued the SEC in a California federal district court, seeking redress for wrongdoing on the part of the agency. It was the initial phase of the legal procedure. According to the complaint, the company's business operations could have been hurt by the SEC's enforcement efforts against cryptocurrency projects because they didn't have clear criteria. The SCLC was responsible for carrying out these operations. The company sought a declaratory injunction to clarify that Ethereum transactions on the Ethereum blockchain do not breach any security-related laws in order to provide further information. Given the apparent simplicity of the matter, it is fitting to apply the theorem and see if it yields the desired result. It should be noted that in contrast, the lawsuit was subsequently abandoned in July due to the lack of proof of any clear conflict between the legislation and the SEC. This led to the termination of employment. This specific reason led to the dismissal of the complaint. As an added note, the district court ruled that the business could not challenge the agency's chosen approach. The reason behind this was that the company had not been subject to any significant action or final decision by the Securities and Exchange Commission. The chances were already against this undertaking, but it still needs to be considered. In order to move on, my name is Erdi. An attorney named Fred made a public declaration on Twitter. It was sad but not surprising that he admitted defeat in the Ninth Circuit today. At the time they submitted their motion, he was hoping the court would give them the chance to clarify that Ethereum is not a federal security. He wanted the court to do something about this. But the Ninth Circuit Court of Appeals affirmed the district court's decision that they lacked the authority to sue the SEC to get an answer to his question. That decision had come from the district court. Ethereum-based exchange-traded funds have not yet received permission from the Securities and Exchange Commission over whether Ethereum and the Ethereum network constitute a security. The current position of the Securities and Exchange Commission is this: even if the Commission does decide that Ethereum is or may be a security under the Securities Act, it may never actually make that determination. Another consideration is that for the time being at least, the courts may not be able to settle this issue. There are other avenues they can pursue to encourage the SEC to provide a response, according to Frederick, and the question they were hoping to have addressed does not represent the way the rule of law should function in the U.S. According to Fred, there are a number of additional choices that they can consider. James Murphy, also known as Metal Lawman, is an attorney, and he praised the firm for standing firm against those who would undermine American democracy and the rule of law. In the legal profession, Murphy has made a name for himself. He said that the decision is ridiculous in his comments. Furthermore, he elaborated by saying that the SEC will continue to act as a group of selfish, incompetent individuals. Furthermore, he assured us that these items would remain unchanged. The firm and the SEC are currently embroiled in a legal battle, and this is a significant step toward a settlement. Finally, the decision by the SEC to hold off on clarifying how Ethereum and its native currency Ethereum are classified as a major step in the right direction toward finding a solution. The video has ended. Send your gratitude to whomever liked and commented on the video. The way YouTube functions is improved. In order to spread the news, please share this video with many people.